Welcome, everyone. Today's training is focused on two clinical policies that protect our clients and ensure JADE Wellness Center remains compliant with federal and state laws. We'll cover how to handle law enforcement interactions and how to respond to legal requests such as subpoenas and search warrants. The goal of this training is to equip you with the knowledge and confidence to respond appropriately and protect client confidentiality. Let's start with our policy on law enforcement entry. Law enforcement officers cannot enter our facility or access client information without a valid court-issued warrant unless there are extingent circumstances such as life-threatening emergencies. And these refer to situations where law enforcement believes immediate action is necessary to prevent serious harm or death. And that could include a credible and immediate threat to somebody's life or safety inside the facility, a crime committed on site when police services are requested by staff or clients, or a medical emergency where police or emergency personnel need access to render aid. However, in those cases, staff should still notify the facility director or clinical supervisor as soon as possible to ensure that the request is legitimate and handled appropriately. If an officer arrives without a warrant, and it's not one of the circumstances I just listed, here's what you should say. I'm sorry, but we're a confidential treatment facility, and federal law prohibits us from disclosing client information or allowing access without a court-ordered warrant. If you have a warrant, we will need to verify its validity before taking any action. If you would like to speak to our facility director or compliance officer, I can contact them for you. It's important that just like any time a person requests information about a client who the client does not have a signed consent to release information for, you do not confirm or deny whether a client is present. Instead, immediately notify the facility director or compliance officer or any supervisor. All interactions with law enforcement must be documented on an incident report. So let's talk about responding to subpoenas, search warrants, and investigations. If a subpoena is received, notify your supervisor immediately. We must review the subpoena's scope and legality before responding. If it requests client records, we must obtain written consent unless there is a legal exception under 42 CFR Part 2. If the subpoena is overly broad or unlawful, legal counsel may file a motion to quash it. For JADE, these requests most usually come from CYF, who will ask you to testify in regards to your client. Typically, writing a letter of their progress is sufficient, but again, make sure to pass the information on to your supervisor and will help guide you through the process. If law enforcement presents a search warrant, notify your supervisor immediately. Only the records specified in the warrant will be provided. If client records are involved, we must ensure compliance with confidentiality laws. Document all actions taken. If an investigation is initiated by regulatory agencies, we must fully cooperate while ensuring that client confidentiality is maintained. Client consent must be obtained before releasing any records unless legally exempted. And regarding all other legal actions like lawsuits or court orders, if we receive a court order requiring the release of client records, only the requested information will be disclosed in strict compliance with confidentiality laws. Clients will be notified unless prohibited by law. And to fully understand why we have these policies, let's briefly review HIPAA and 42 CFR Part 2, which should sound familiar from your confidentiality trainings. They are two primary laws protecting our clients' confidentiality. HIPAA, or the Health Insurance Portability and Accountability Act, ensures the privacy and security of all health-related information. It allows disclosure only with client consent unless a legal exemption applies. And it protects information shared between clients and providers covering medical, mental health, and substance use treatment records. 42 CFR Part 2 is the confidentiality of substance use disorder records. It provides stronger protections than HIPAA for clients in substance use treatment. It requires specific client consent before disclosing any treatment-related information, and prohibits sharing client information with law enforcement, even with a subpoena, unless a court order explicitly allows disclosure. These laws mean that we have to act as a protective barrier between our clients and any external requests for their information. Just because law enforcement or legal entities ask for information does not mean we can give it to them. Our job is to follow these laws and protect our clients' rights at all times. At JADE Wellness Center, our responsibility is to protect our clients' rights and confidentiality. Law enforcement and the legal system can make requests, ask questions, and demand access. But it's our job to act as a barrier that ensures our clients' rights are being upheld. Confidentiality is not just a policy, it's a legal and ethical obligation that we take seriously. If you're ever unsure how to handle law enforcement requests or a legal document, pause, consult a supervisor, and follow policy. Never feel pressured to provide information without proper legal review. By following these steps, we can ensure that compliance with HIPAA, 42 CFR Part 2, and state laws while protecting the trust our clients place in us.